21st April 2021.
21st April 2021.
Yeah.
Would you wish... You are addressing us with regards to exhibit number 114. Please describe to the court what is exhibit 114.
This is a letter from the land registrar, senior land registrar, N.D. Nyamboso, but we popularly know him as Nyandoro, dated 3rd July 2023. This was the genesis of 3rd July 2023. This was the genesis of the problems between me and the ministry. In the second paragraph, Nyandolo confirmed that he had my file with him. And then he went ahead and said he had ordered me to hand over my file for cancellation, or show cause why it should not be cancelled. And he and registry, central registry. But should anything go on, it will not be done without the knowledge of your client. And the client meant here, this letter was addressed to Macharia, and the client meant here is the complainant in this case.
Please tell us the full details of the addressee.
Macharia, Mwangi, and Jeru Advocates, Garissa Gardens, Annex 6th floor. Macharia, Mwangi, and Jeru Advocates. These are the advocates for the client.
Who is that client?
The client is the complainant in this case, Ashok.
What transpired?
One that Machari had written to Nyandolo. And in his correspondence, although there are difference to me, I'm not copied this letter. It was action meant to isolate me.
That nowhere.
Please help to provide information that might help in the reconstruction of this fight.
Mr. Chelogoi, in your of the said HKM associates, have you ever been associated with them in any way?
No, not at all.
Do you know them?
Not at all, except now their name as.
So it is your evidence before this court that this and the advocates
in this letter, maybe I should mention very importantly, it was a biased letter. Isolating me from the transactions that were going to on.
Your Honor, we are referring to exhibit number 6.
The complainant and his partner, and then myself, and were asked to deliver I put up a Sakamuyu, the signatory of this summons, to say already Nyandolo in his letter, which I have just referred to 3rd July 2023, He has already said he wants to cancel my title. So what is the purpose of the summons when already he has made a decision? That letter didn't reply, but it was nevertheless stamped as received. So on 27th, and that letter is on 27th July 2023, the Committee of Land Registrars, and these were Joseph Kamuyu, who testified in this case, Faisal Sweti didn't testify, but in their ruling following the summons, with your permission to read.
Now we are making reference to Exhibit 8.
And in this letter, again, I filed a protest dated 27th July 2023.
Your Honor, we are making reference to the protest letter by Davis Nova Chelogoi. It's Exhibit 107.
And in this complaint letter, I was insisting that they should not proceed with the registrar's I felt nearly undermining already the case filed before ERC E070 2023. Despite my complaint, the registrars proceeded with their ruling. And in their ruling, I'll read the last paragraph on page 3, item number 1 on page 3. I'll read it for purposes of clarity. The document presented by Ashok Kumar, the Shah, and Hitenkumar Raja, number 184-85, rejects forms part of the records held in the ministry. Your Honor, I wish to mention here that at the time this ruling is being done, the reconstruction that they are talking about has not yet commenced. And 2 to 31 years from the time when this property was registered, and he had never been in the system, both in the Survey of Kenya and the Ministry of Lands, who are the custodians of all these properties. And this is testified by various witnesses, both from Survey of Kenya and the Ministry of Lands. So that is a very important issue related to this letter. Now, then the office is cognizant of the fact that ELC case 312-209 declared that Ashok and his partner are the bona fide owners of the parcel. The orders of ELC and the execution of the decree dated 28 July 2020 have not been stayed. Another very important milestone. 312 of 2009 and the ELC 312 of 2009 did indicate very firmly that Chelogoi was not a party of those proceedings, and so he cannot be compelled to be a party to it.
Now we are referring to the rulings in DB, produced as Defense Exhibit 20. The 2 rulings produced in court.
21, just like
I'm a party to this court, and the High Court, Environment Court, had rejected that assumption. And then number 3, the ongoing process of indemnity to reinstate, and this is important again, to reinstate the lost or destroyed register in respect of the same R number shall be completed. For the avoidance of doubt, the record shall then form part of the record held by the registry, both in manual and digital record, on the electronic documentation management system. Now, this again is another very explosive point, because this again talks about documents which have not been in the system for over 29 years, 31 years rather, and they are received one day, and then they are taken that they are genuine, no forensic audit. And interestingly, when the IO was carrying out investigation on this matter, he deliberately left out to include these documents for forensic audit and just dwelt on ours. And so, very surprisingly, documents which have not been in the system for 31 years, as attested by various witnesses, both in Survey of Kenya and Ministry of Lands, can be validated within a day to be genuine documents. And this is exactly the scandal that continued from now onwards. Everything that was done was fraudulent, as I will indicate from the subsequent documents.
Mr. Chelogoi, you have indicated strongly that the documents for the complainant were not subjected to any forensic audit, correct?
Yes.
If I take you to the forensic document examiner report and the exhibit and the exhibit memo, that's exhibit number 80 and 81. Were the documents for the complainant submitted for forensic examination?
No.
Is there anything to show that those documents up to date were ever subjected to any forensic audit?
No.
To which title was the forensic document examination report concerning?
It was only concerned with the document Chelogoi.
Thank you. You have mentioned the issue of an indemnity. During the hearing and with the witnesses presented when you were seated there, did the prosecution provide any document of such a nature of the deed of indemnity? In the bundle of documents, did you see any document such as a deed of indemnity?
Yes, I think they presented.
Did you leave the one in the title? Leave the one in the title.
Yeah.
Did you see an actual document submitted to this court as an exhibit?
No.
As a deed of indemnity?
No.
In your understanding, perhaps this if you don't know, you can say, what is the purpose of a deed of indemnity? If you're not sure, just don't even go to it.
I'll try. The purpose is that there's an assumption in this LR number that documents were lost and destroyed. And therefore, you are paving way to gazette the recovery of those documents which appeared in a newspaper.
That's a fair explanation.
Yes.
So, was there any evidence led by the prosecution or any witness who came to this court to provide a police abstract on the said loss?
No.
Did the complainant present either an affidavit, an OB, or any report written to the Ministry of Lands on the loss of his title?
No.
Was there any formal letter from the ministry to the police officers requesting, or to the DCI, requesting investigations on the loss of title belonging to the complainant that have been presented before this court?
Not at all.
So it is your evidence that the presentation of the deed of indemnity that has not been presented before this court, created an assumption of the loss.
Yes.
When was this deed of indemnity that was referred to in the title? You're now referring to exhibit number 2. What is exhibit number 2?
Dated 6.
Just the title. What is the exhibit number 2? Exhibit is the title. What is exhibit number 2?
This is the title.
The title
18485, IR number 64011.
64011. They have made reference in the title of the deed of indemnity. When is it dated?
6 April 2023.
6th April 2023. When was it registered?
Registered on
When was it registered?
19th May 2023.
When was it registered
No.
as a title?
Or 16th April 2023.
16th?
16th August 2023.
Mr. Chelogoi, the document is before you. Please read there the dates of when it was registered.
16th August 2023.
That is when that deed of indemnity was registered, correct?
Yes.
Will it be wrong to say that from 16th of August 2023, that is the first time the documents for the complainant surfaced in the Ministry of Lands?
Yes.
And if that is the position, with your title having been registered on the 4th of June 2021, will there have been any offense in your registration of your title?
It was never pointed to me at any one stage that there's anything wrong with it, except that letter which intimated that I should surrender for cancellation, and no reasons were advanced.
So it is your evidence before this court that at the time you're getting your title, the title that the deed of indemnity was registered against was non-existent.
Yes, non-existence.
Mr. Chelogoi, at the time of registration of the deed of indemnity in Exhibit 2 was done, had you sought to be enjoined in the proceedings in ELC 312?
Yes.
And now we are referring to the ruling of 20th July 2023, Your Honor. The ruling was presented 2023, Your Honor. The ruling was presented in a bundle of documents and it was produced as Exhibit Exhibit 104. Mr. Chelogoi, at the time of being enjoined in the proceedings,
that in that the judgment on the grounds that I had advanced earlier, and then two were allowed
to participate in post-judgment applications.
Yes.
For you, exhibit number 118. Exhibit number 118. 118. Please tell the court the date of that letter and to whom is it addressed and who is the author of that letter.
This letter I wrote on 11th October 2023, and I was addressing it to the Cabinet Secretary, Ministry of Lands, Public Works and Housing. And I was making a reference, and this was a product of all these activities that were very strange and, in fact, fraudulent in the Central Land Registry. And I detailed the various complaints on the fact that my documents are being destroyed by land to force in documents which they had not been there for the last 31 years.
Okay. So you confirm to this court that you did a protest letter with the activities, the ongoing activities at the Ministry of Lands,
Yes,
correct?
yes.
The Cabinet Secretary.
Yes.
Other than the protest letter, was in Exhibit 8 presented to court in any way?
No.
Was the ruling presented at Exhibit 8 ever been adopted by any court to warrant your eviction?
No.
Yes, yes, yes. I'm just.
So that when we go around and all that, I'm trying to wonder how. And I wonder how I'll put them down with people office, procuring registration, entering, all that.
Yes, because the last time they said the prosecution had indicated that it was not contested. That's why I was just presentation. Because we're in count 6.
Okay,
Mr. Davis, nothing to look at. Procuring of registration. Mr. Chelogoi, upon receipt of, who did the conversion of the suit property?
I did the conversion. This is following the 10 September 2021 Kenya Gazette notice, that is, which the Cabinet Secretary, Ministry of Lands and the Gazette notice that invited conversion was 10 September 2021. And we surrendered via 2 letters to the Director of Survey. One letter was dated 22nd September 2022. And this letter was signed by Charles Ngetich. And then there was another one of 9th March 2021 of 5 deed plans that was sent. 8th March 2021 by PM Tour to the Director of Survey.
You're not referring to Exhibit 34 and Exhibit 98. In the surrender, did you make any payments to the ministry?
Yes, I did.
Well, which date did you make the payment? When was it received?
15th June 2021.
15th June 2021.
And this was in respect to the surrender of deed plans. And I paid 1,878.
Will you wish to produce
Yes.
the application for surrender?
Yes.
When I wish to produce the application for surrender for 15th June 2021 as Defense Exhibit 24. After the surrender, what happened?
The Ministry of Survey then go to the Director of Land Administration for the RM, that is Registered Index Map Amendment, Nairobi Block 8, parcels number 44 to 72, being conversion of former LR number 18485, which had been subdivided into 29 plots from 2 to 30.
So we are referring to Exhibit 94. Mr. Chelogoi, just for clarification, who collected the registry and to whom was the registry index map issued to by the Director of Survey?
the director of survey through the land administration forward these items, and they were collected by my officer, Limo.
Do you have the original registry index map as you claim?
Yes, I do. There are 2 copies, I think, but this is one of them. This is what they look like. This is the letter that I've just referred to.
Exhibit 24.
And then the map is this one. The index map is this one. So these are now the plots as a product of the surrender of these plans. They are from 44 to 72. And these were originally from 2 to 30 in the old map. And I have the original RMs, the original.
Do you wish to produce the registry index map?
Yes.
No, we used to produce it as defense exhibit 25. Now that you have the charge before you, Mr. Chelogoi, is the procuration count number 6 of Nairobi block 80, 44 to 72. After obtaining the registry index map, were you able to go ahead and obtain the titles using the registry index map?
Following the complaint that I had made to the minister about the interference in my file in the ministry, we went ahead and filed a case in ELC 312-2009 about the same complaint. And following that application, a ruling was given on 22nd of April 2023 saying we stop any transactions. The orders which were contained in the judgment were, this was in E070, yes. So I was saying, Your Honor, that we filed an application to E070 of 2023 regarding similar complaint because there was no response from the ministry.
Clarify the court, because the court is right. Which case did you file?
The one about the 22nd of April. The ruling.
Which case? Because the court is recording.
Yeah, E070 of 2023.
In that case, who are you in that case?
I'm the plaintiff.
And who is the other party, the complainant?
The complainant is the first defendant. His second partner is the second one. And then Commissioner of Lands is the third, and registrar is the fourth.
In that proceeding, have they participated in any way?
They didn't participate.
Or rather, let me rephrase the question. Did they file anything in that case?
They filed, of course, a response to the application we made to E070. But when the ruling came on 22nd of April 2023, orders were given. One of the orders was status quo be maintained. And the judge said, additionally, and for clarity, that was our deal. For clarity, Chelogoi to continue.
Because we are repeating the point.
And then again, I don't know how I'll be able to analyze a ruling by a judge. That's why
That is.
so when he continues saying
I was
what the
trying
judge
to.
said, I wish I was at the Court of Appeal.
That is.
Yeah, but at my level, when all that is said, yes, I can write, but I rephrase your question so that we get back to the charges.
Yes.
But you know, when everything, the court is being told about what the High Court of Equal Status did, I think I'll be surpassing my limits.
Yeah. We take notice of the same.
Yeah, it's good for him to say, but there's nothing I can do. Because if I will put that in my judgment, then, you know, jurisdiction is everything, and when you don't have it, you down your head.
That is true.
Yeah, so
that is
even if you take me through, I don't sit at the Court of Appeal.
Yes. Mr. Chelogoi, Registry Index Map. Were you able to proceed to go ahead with the registration of the 29 titles?
Your Honor, this is what I was explaining, that the court stopped us from proceeding with that registration. Both of us. We should not proceed to register the new RM until E070 is had and determined. That was the point I was making.
I would like to put to you, there's a document before you. The prosecution presented the 29 titles in this court as exhibit number 13. Is there any...
Now, when you say that, now when the court stopped,
yes.
I'm not writing, the registration of all the titles, did that happen?
You're
no, you see, I'm talking to and I'm not writing, yes, as counsel.
Yes, well, when the court stopped the registration, the ruling was on the 22nd of April. The charge sheet was amended sometime in...
No, the court stopped. That is the higher court.
The high court.
Okay.
ELC.
And when they stopped it, what did you do?
When they stopped it, that's where I'm coming to.
No, it's here I'm talking to, because I don't want to write. If he talks, I'll write. It's here I'm talking to. I believe because you are counsel in that matter.
Yes.
And then what did you do?
We protested.
And in the same court?
We protested. When the court, we went to E070 and we filed an application. An application based on a letter he had written that his documents in the system, in the Earth server system, were being removed and being replaced with those of the complainant. And now that we did not get any response from the ministry, because the letter was addressed to the cabinet.
No, I just want to have the court stopped that both parties not to register.
Yes.
Were they registered?
Yes, they are registered.
Okay, when they were registered, what did you do?
We filed an application in court.
Proceed from there now.
Perhaps what the defense is not telling the court, yes, there was an order for status quo in E070 of 2020, but we later on stayed these orders. That's not what they are telling the court.
Perhaps
we have very kind that point of the Court of Appeal.
With your very kind permission, and I get the sentiments of the court, I believe counsel is alluding to is that after the court order was issued not to do any further registrations, they were subsequently done. And we entirely agree that proceeded. But then the charges were amended to reflect
what
the
I'm
amendment.
asking, you see, the court up there has happened. Because what you're saying is I went ahead and registered. Is that the position?
That's the word.
Now, when they were registered,
yes.
What, as counsel for the accused, what did he do? That is what I want to know.
Perhaps
because what I'm having a problem is, I'm down here, unanipeleka ELC, you know very well I can't do anything about the ELC matters. I'm really restrained not to ask questions.
Perhaps with your kind permission,
right.
let me just enumerate this. The court issuing directions or orders not to register. The registration was subsequently done. Now, what counsel is raising, I believe, goes to the root of framing the charges. That the court at that point...
Wait, they went ahead and registered. What did you do as counsel?
So
because
now,
there's a note at the ELC.
Yes.
What did you do?
So now the accused person is facing charges.
No, you're not getting me.
Yes.
No.
That I think should be the evidence.
Okay, I know,
yes.
and I'm not writing.
Yes.
You're trying not to get to ELC because it's a higher court.
Yes.
you've been told status quo to remain.
Yes.
But you've told me this court that they went ahead and registered.
Yes.
So when they registered, because there is an order, what did you do? In that registration up there, forget about the lower court
Yes.
now. The court there has said nobody, neither party to register,
Yes.
right?
Yes.
But one party, as per what you're telling me,
Yes.
has registered.
Yes.
What did you do?
Mr. Chelogoi filed an application
And
before and she went ahead and she expressly stated that the titles of LR 18485 held by Ashok and the titles for Mr. Chelogoi, the registrar, the land registrar, not to change or amend, because we had raised it as an application.
yes.
And with the letters.
And then what happened eventually?
There was no
Yeah, so that is what I'm saying. You see, that's a higher court. It's
Your
a
Honor,
higher court, and that has happened.
With
So,
your very kind permission, the issue registration.
okay, and then
The
he has-
issue
he has
is-
told you so. Let
Yes.
him continue now.
Yes, the issue
He
is
knows now. That's what I want clarity.
it's not the effect of registration.
Okay, fine.
It
So-
is the effect of having a registration done. Then the accused, not my client, he's a client, facing charges emanating from a process that
has
has
been
been
stopped.
injuncted. So it goes to the root of the charges he's facing.
Okay.
Yes.
Let him now pick it up from there.
Yeah, that I think is
when the ruling was entered. Were these fresh charges presented to you with respect to Nairobi block at the time the ruling of ELC was entered on the 22nd of April?
Say it again, your question.
At the time of the ruling of 22nd of April, were the fresh charges you are facing today concerning Nairobi block sorry, I'm going to by the time of the fresh charges, was there already a ruling stopping the title, directing that the titles remain as original?
There was.
So it is your evidence that the charge sheet as presented today was on the background of a ruling which had said that the titles remain as they were.
Yes.
And when you say as they were, it means LR 18485, 64011, and 18485, 2329008.
Yes. And in addition, Your Honor, if you may allow me to add, the complainant, well aware that they had disobeyed these orders, immediately filed an appeal, 207, which appeal was intended to block us from further action. And indeed, they filed. It is now a case of 700 of 2023.
Was there a ruling to that effect? That appeal?
The court order said,
No, don't go to the court. Was there
No,
a ruling?
It's important because I want to know, you said yes, then it was charged, what you say. So I wanted to know what action did you people do when there was that contempt?
We not only filed, because the deletion of his documents happened prior. The deletion of his document.
The status quo to remain,
Yes.
pending the hearing.
Yes.
Now we've gotten to something very critical. Like there is contempt.
Yes.
You've seen that the court has said this, but they've done this.
Yes.
So what did you do? Did you file a contempt?
We filed an application in court. An application. First, the accused person went ahead and wrote to the CS.
So did you file a contempt?
We did not file a contempt.
Okay, let's proceed.
We filed an application
Let's
which
proceed.
led to the ruling.
So you did not cite them for disobeying the court order. You did not cite them.
The timings are important. The deletion commenced earlier than.
You see, I'm getting to what you're saying.
Yes.
Status quo has been said by J. Omandi.
Yes.
Do not do anything, status quo to be maintained. But one party goes ahead and does not do what the court has said. Okay? Then that is where my question comes in. What did you do?
Your Honor, let me clarify that. after the complainant disobeying that court order and proceeded to Court of Appeal allowed that their application to stay the order. But we responded because we had to respond, and we put a very emphatic displeasure in the way complainant had disregarded the orders and moved to Court of Appeal.
What did the Court of Appeal do?
We are waiting for the actually for the hearing of the appeal has not yet been had. But
So
also,
it's a live matter.
it's
So
a live
that's
matter.
why let's be careful.
Yes, it's a live matter.
Careful.
Yeah, it's a live matter.
Let's be careful, because I don't want those complaints whereby say that, but the magistrate's court decided to sit on our appeals, and let us be careful, counsel.
Yes.
Because if they are live matters, you know very well that it should not be. In fact, it is subject.
That's very important. Mr. Chelogoi, you have told this court that the title was issued to you after the verification of a letter of allotment, correct?
Yes.
You have also confirmed to this court that the title was issued by the Ministry of Land
Yes.
and by Mr. Charles Kirungu, correct?
Yes.
In your recollection of evidence presented by PW16, Mr. Charles Getich, what was the basis of him proceeding to register your title?
Ngetich, alongside other witnesses, did say at the time of registration of my title, there was nothing in their system. There was nothing in their systems. And he sat over it for a long time, about 6 months. He said, eventually, he registered the title because there was nothing. And indeed, if you look at the dates of the indemnity, confirms what Ngetich was talking about. There was nothing. And this is why reconstruction was being put into the system after the time we had already registered our title.
So it is your evidence, in line with the statement and testimony given by Charles Ngetich, that at the time of registration of your title, there was no any other title
There was nothing.
in the system. And it's also evidence that at the time of the deed of indemnity that has been presented by the complainant, there was nothing, no other title registered in the system.
Nothing.
So David Nathan Chelogoi, you have seen the 29 titles that was presented as Exhibit 13, correct?
Yes.
When were they registered?
They were registered on
And how many titles?
They were produced, the 29 titles, produced as Exhibit number 13. Number 13. So 29 titles. When were they registered?
on 15th February 2024
15th February 2024. To whom are they registered to?
to the complainant, Ashok and his partner.
Shah and his partner. In your recollection, did the prosecution lead or provide any evidence to show that you participated in the procuring of these 29 titles?
They didn't, and they were right because I didn't.
Is there any document that has been presented before this court to show your name participating in the procuration of these titles?
No.
Chelogoi, you have is there any time when you were summoned prior to the institution of these charges by the DCI?
Yes.
did you make any response or clarification to the Director of Criminal Investigation?
Yes, on 24th October 2023, I wrote a complaint to the Director of Criminal Investigation. 24th of October 2023. I wrote a complaint to the Director of Criminal Investigation, detailing these criminal activities that are being perpetrated by the land registrar in connivance with the complainant. And indeed, Your Honor, the Director, CID gave me audience in his office for about 3 hours. I went through all my documents with him, and he was satisfied that there is no crime that has been committed, and he ordered the investigating officer, the IO, Mr. Osuri here, didn't turn up, but the director had called both of them, but Osuri didn't turn up, but Kimutai was leading the investigation, was directed to stop all this criminal investigation, both for Ashok and myself, but go to the ground and confirm.
You're saying that the DCI
the DCI, following this complaint, which I've just talked about, gave me audience for about 3 hours. Upon completion of 3 hours discussion, someone the leader of the investigation in time, and Osori, who was the IO, to come to his office while I was seated there. Mr. Osori didn't turn up, but I learned later he had come to the regional office to collect the duplicate file of my complaint, file number 27.
Mr. Chelogoi, so it is your evidence that you lodged the complaint on the 24th of October, correct?
I did.
2023. You wish to provide the letter to the court, is it?
Yes.
You wish to produce this as defense exhibit? Mr. Chelogoi.
I wish to add a small one. That the director, after summoning Kimutai Tanda, and he said, please terminate all these investigations for Ashok and Chelogoi. He's satisfied with the explanations and the documents that are given. Yes. And
yes, I think he's your witness, right?
Yes, yes. Mr. Chelogoi, as we stand today, has there been any court order cancelling your title to date?
no.
Have you been involved in any proceeding that has cancelled your title?
No.
Any court proceeding?
No.
For how long have you been in occupation of the parcel of land?
Close to 28 years.
Close to 28 years. And during these 28 years, has there been any eviction notice or court order issued for you to vacate the property?
No. Several attempts have been made through courts, through illegal actions, but I didn't get out.
So the courts have done that?
Yes, the court rejected all the applications, 11 of them, 6 in the High Court, 4 in the Magistrates Court. The courts rejected those efforts to evict me, saying under Article 5th of the Constitution, I'm entitled to be heard.
Mr. Cheta, official letter that you've seen presented by the prosecution from the Ministry of Lands denying or denouncing your title as fake?
There is no letter that I've said it is fake, save for the ruling of 27th of July 2023, that meeting that was made by the registrar. That is when they said Chelogoi was free to court. They had cancelled my...
You're not getting my question. Is there an express letter from the Ministry of Lands stating or declaring your letter of allotment and your title deed as fake or a forgery?
No.
Is there any letter from the Ministry of Lands or any evidence led before this court showing or saying that the letter of allotment issued to you and your certificate of title did not emanate from the Ministry of Lands?
No.
Mr. Chelogoi, in your understanding, can you cancel something that is not in the system? Hypothetical, it's a hypothetical question. Can you cancel something that is inexistent?
Because the matter is already residing.
Answer my question. Answer my question, Mr. Chelogoi. Yes or no? Can you cancel something that is inexistent?
You can't.
I refer you back to the letter of Mr. Nyandoro. From the letter of Mr. Nyandoro, the Chief Land Registrar. You know, that is exhibit, I believe 104. Is there anywhere in the letter of Mr. Nyandoro, the Chief Land Registrar, saying that your file is there any letter from the Chief Land Registrar, Mr. Nyandoro, that has been present before this court, stating that your land records or your title is fake of a forgery?
He never said any of that, but he said he was recalling it for cancellation.
Were there any reasons given to you, either expressly or otherwise?
No.
Directly?
No.
On why you had decided to cancel?
No.
Are you currently in occupation of the suit property?
No.
Please explain why.
Besides the E070 that was stated in Court of Appeal, there were no orders that were given, but we had orders in Procedural of T009, which said status quo be maintained.
Mr. Chelogoi, my question is very simple. We're trying not to delve into the ruling. My question is very simple. Are you on the property as we speak?
I've said no, but it's important to appreciate the circumstances.
When did you leave the property?
I didn't leave voluntarily. I was evicted by a team of over 50 policemen, led by the OSPD Gilgiri and accompanied by Mr. Ashok, the complainant, with over 10 security guards. So there were a total of combined security of 72 people.
When was that?
30th July 2025.
30th July 2025. Were you on site when they said eviction happened?
My workers were on site.
On site.
But I went and joined to find out from these people the actions they were undertaking. What is the legal basis? OSPD and the DCIO confirmed there was no legal basis. They had been given orders by their seniors to not even to evict, because the letter you are referring to didn't talk about eviction. It said charge anybody who is on the ground, unknown people. And yet they knew I have workers on the ground. I don't live in that shamba, but I have workers guarding that property.
You have made reference that you confirmed that you went on site. Were you shown any eviction notice?
No,
Were you shown any eviction order?
no,
Were you shown of any proceedings that had been lodged which occasioned such an eviction?
not immediately on site, but after exhaustive search of the circumstances that would have led such a powerful force of police and carrying Ashok with them to the shamba around 6 o'clock in the evening. The DCI gave us a copy of this letter which you want to refer to. And in the letter now is where we found that Mr. Ashok had again opened another criminal case at the DCI office, regional office. Aware that we are here, but we went and opened another case in that is 113.
So there's another live case.
Yes.
So let's not get
There is I just wanted to bring to your attention that bit of it. So, Mr. Chelogoi, as we sum up,
This is very important.
No, the thing is, can you tell your client when there's a matter ongoing in another court, it is very dangerous to dwell with it, because again, it puts me in a very bad taste that you were made aware, but you went ahead to.
Your Honor, the problem I have is that it is that very action that is ongoing now. That is why we are
No,
here.
you said it just happened the other day. This matter
30th,
went to court in
30th
2023.
July
So this has
2025.
come after. So I don't know how you want me to delve into that, counsel?
No, no,
no, I don't want to. At least it has been brought to the attention.
but Your Honor,
And
I
it's
wish,
ongoing.
as the affected person, is that the charges which are contained in that letter from audit PP, which being a signatory, are the same charges that are now here in the door.
So I think that
explaining.
your counsels will bring it to the attention of,
Yeah,
I don't know
that
which court it is. Yeah. They will bring it to the attention of that other court.
Okay.
Are you both in the matter?
No, we are not.
Like him?
We are not.
No, I'm asking because he's brought it up. That's why I was trying to. Let's not. He's saying that there's this one and there's another in another court.
Yes.
Okay. So have you brought it to the attention of that other court? Counsel?
Yes, Your Honor, I'm representing some of the accused person in that
So you,
file.
you brought it to the attention.
Not really, but I believe the issue to deal with the merits.
We are not
that-
dealing with the
Let's
merits.
show
Just
you
to
that
bring to speak.
what has happened is that there is another case that has been opened.
Yeah, so deal with it in
With
that so
that
that I
point.
stay on my lane.
Okay. Mr. Chelogoi,
Your Honor, allow
Let me tell you, counsels, let me tell you. You know, you people bring them here. But at the end of the day, there are those letters that, it's the same parties that you send letters to the court of, to the JSC. That the magistrate was made aware that this matter was going, but she went ahead to deal in that. Those are the things I'm trying to avoid, yeah. And your lawyers, you know, if it's a matter ongoing, we cannot tell you. But if it has come after this one, you equally know what to do.
thank you. Thank you. Mr. Chelogoi,
So you can bring appeal in the other court so that it is stopped and then you proceed with this one.
Mr. Chelogoi, you sat. You sat and you saw witnesses who are brought before this court from the survey of Kenya.
Yes.
How many in your recollection were called?
I think there were about 6.
How many?
6 or 8. I think there were about 6 or 8.
So, but you confirm there were officers from the Director of Surveys who were called.
Yes.
Did any one of them dispute having knowledge of your records at surveys?
No.
Did any one of them expressly state that the records in their possession reflected the title being held by the complainant?
No.
Did the witnesses confirm to having certified as true copy the deed plan registered, which was used to register your title?
Yes.
Was there any evidence from those said officers stating that the deed plan had already been used in registration in another title?
No.
Mr. Chelogoi, was there any official from the Nairobi City County who was brought before this court?
No.
Is there any evidence in form of a letter or a report from the Nairobi City Council authenticating the land rates and the land clearance certificate held by the complainant?
Yes, there was.
Sorry?
There was a letter.
The letter was confirming what?
The letter was confirming that in their systems, Chelogoi is the only person paying the Registry Council.
You have mixed me. Was there, here my question, was there any letter from Nairobi City Council authenticating the land rates and land rate clearance certificate of Mr. Ashok, Shah, and Hitenkumar?
No.
And was there a letter from Nairobi City Council, City County, authenticating your land rates and clearance certificate?
Yes.
You're clear?
No.
You're not clear? Can I repeat again?
They were matters of rates.
Matter? Yes.
That's what you asked.
Yes, but
so ask it now.
On the matters of rates?
That's what you're asking.
Yes.
Go ahead.
Was there any letter from the Nairobi City County validating the land rates receipts and clearance certificate issued by the complainant?
No.
Was there any letter from the Nairobi City County validating your land rate receipts
Yes.
and land rate clearance certificate?
Yes.
And you provided the evidence before this court.
Yes.
Who receives? Let me rephrase it. Are you receiving any notifications of rates and default notices?
I do.
While you sat here, did the prosecution lead or present any evidence from the complainant of any default notice that had been issued to the complainant?
Not that I remember any.
From your record, what is the outstanding land rate, if indeed?
As per last month, I'm now in arrears of 2 months, which is 3.6 something million shillings. I'm in arrears of 2 months. For the very reason that this court has destroyed all my incomes to promptly pay.
Please. You are now attacking the court.
I'm saying, madam, that this case, as launched by the complainant, has undermined my capacity to pay my rates on time the way I used to.
Is there an order to deter him from paying the rates?
Sorry?
No, I'm asking counsel. If that is what he's saying, that is there a court order that has deterred him from paying his rates?
No, there's no court order. So, Mr. Chelogoi, rephrase you confirm, just to avoid going there deep, you confirm that you're the one in receipt of the default notice.
Yes.
And you're the one whose account is still running to date.
Yes.
Mr. Chelogoi did the subdivision for the property.
No.
please explain the reason?
The reason why I didn't do the subdivision was because a stranger whom I didn't know then, but I have now known is in the company, had abandoned the LR number 11653 that they claimed for over the years and went into a GL which I'd applied for, and the one that I was already in residence. Went ahead, did a survey, proceeded with a subdivision, and got a title outside the systems of the Ministry of Lands and the Ministry of Survey.
Thank you for that information. That information, where did you obtain that information from?
That information came about, remember I'm a political scientist, and political scientists do empirical studies. We do research to find out this conflict I'm having with Ashok, what is it? Because in the letter of allotment, it is talking about a different island of Ashok. The PDP is different. The sizes are different. So what was the issue? That is the background, and it's important to appreciate why I had to do deeper research to find out what happened.
Did you engage any services, professional services, to be able to get the information?
Yes.
When did you engage the professional services?
I instructed Professor Gender in 9th April 2024 to engage a licensed surveyor to dig into this complicity of these other LR numbers.
Was there anything that was forwarded to you?
The licensed surveyor forwarded to me a report, which report I have it now with me, and I think it was served earlier to the prosecution.
You know, we refer to letter dated 9 February 2024 from the accused person's former advocates, instructing Gapi Consultants. There is a submission letter directed to Mr. Davis Nathan Chelogoi on the 19th September 2025. We wish to submit the same.
19th September 2025. What is
It's
this?
the forwarding letter together with the report. We wish to produce the same as exhibit 27. Mr. Chelogoi, lastly, as I conclude, was issued by the Ministry of Lands.
Yes.
You confirm that the entire process of registration of your title was done through the ministry.
Yes.
You confirm there is no evidence that has been presented before this court to show you having any influence to the officers from the Ministry of Lands in the process of registration.
No.
You confirm to this court that the documents, that the title documents has a train or a chain of communication and correspondences.
Yes.
That is all, Your Honor.
Are you okay? You want to sit down?
I wanted to make that request because yesterday.
This morning. And my first question is that would you kindly confirm to the court whether during the transaction that you were dealing with in reference to the location of this land, did you ever meet with A accused number 2?
No, except in this court.
So So then it is your evidence that the first time you met A2 was before this court.
Yes.
You sat through the evidence of prosecution witnesses. These are 19. Did you see any of them provide communication between yourself and A2 in respect to the alleged conspiracy?
No.
Was any agreement for the conspiracy tendered as evidence before this court?
No.
Was telephone communication or triangulation between yourself and A2 presented before this court?
No.
Was your telephone number well known to the investigating officer at the time of the investigations? Did he know, did the investigating officer ask for that telephone number?
Before, no. But when I went to record a statement, I gave it to him.
So you confirm that before you were charged, that telephone number was available to the investigating officer?
Yeah.
And have you seen any evidence or call data records that were taken from that phone that linked you and A2 in a conspiracy?
No.
Thank you. Have you ever worked in the Ministry of Lands?
No.
Would you know, perhaps, who has the duty of verifying the letters of allotment that are submitted to the lands?
I wouldn't know. As I've said, I don't work there.
You don't. Thank you. Would you confirm whether it is yourself who submitted the letter of allotment?
It's myself who submitted.
Thank you. Did you submit that letter of allotment to A2?
No.
During the registration of that process, did you in any way influence A2 either by gifts or corruption or undue influence
No.
to register that parcel of land in your name?
No.
Has any evidence been tendered before this court that shows the benefit accused 2 is going to derive from the transaction?
No.
You did sit through the evidence of the prosecution witnesses, and I will take you to prosecution witness number 7, who was a registrar of lands. And also PW8, who was from survey. PW9, who was also from survey. PW10, who was from survey. PW13, who was from a land registrar. PW14 from the Ministry of Lands, who is from the Ministry of Lands. PW15, who is the Chief Land Registrar. And PW16, who is the registrar that signed your title. Did any of those witnesses from the Ministry of Lands say that they were in any way influenced to register that title either by yourself or by 8-2 in your favor?
No.
It's not that way. I'll take you quickly to what would be their statement in respect to whether these investigations are meant to deal with the question of who is the bona fide owner of that land. The investigations, when you sat through and the documents that you've been shown by your advocate. Let me rephrase the question. Do you believe the investigations and the charges are meant to find out who is the bona fide owner of that property?
No, they were meant to victimize.
Meant to victimize. In respect to the investigations that have been carried, when you say victimize, would you say these investigations have been fair to you?
Certainly not. Biased, selective, and intended to achieve a predated objective.
Just a minute.
No, he's still talking.
Oh,
I can only write after he's spoken.
okay.
I cannot write when he's
It is actually my last question.
Let him speak, then I write. Cancel.
We'll just proceed.
I
Proceed with
cannot
your.
read through his mind.
You can't, yes. I thought you would do
I'm
something.
listening.
Thank you very much, Evan. I'm well guided. Now, okay, kindly proceed.
I have said this investigation because it only looked at my document. And yet, according to IO, the objective of his investigation was to determine the true owners of the true ownership of the property. Therefore, what would have been traditional normal is to get the true documents, subjected them to forensic audit. But it's only mine that was done. This is why I'm concluding that this was selective, very biased. And you look at a lot of correspondence, there was a lot of bias that was already planned against me. And I think the objective was to beat me in this case so that they can use it in E07 to influence the outcome of the Environment and Land Code.
The last question is that suit that you're referring to dealing with the question of title to that property? The suit that you referred to?
Yes.
It is dealing, which question is it dealing with in that court?
Ownership. Which
so that is a question and that is a question before in trial in that ELC court.
Yes, the ODPP in his submission.
I wish you can answer that question. What he has asked. What is the ELC giving?
What is it trying to determine in the Environment and Land?
To determine the true ownership of the disputed property.
Thank you very much. That will be all.
Yes. Cross.
Yes, yeah.
Okay. Now, when you're still at that, you have most people feeling late apart from this particular one.
Yes,
So I think I've learned for yourself. That is why we have been able to reach where we are. You've done well, time, because we had agreed at 9. And we were here at 9. Now, for the latecomers, now you mention your matters. Because every other person came after 9. How many were danganya? So can you mention those other matters?
Number 2 in the course list is coming up for defense hearing.